Having understood how the arbitration proceedings commence with the preliminary meeting and what exactly the proceedings will entail, like filing section 16 applications, 17 applications, the statement of claim, the defense, counterclaim, etc., let's get to the pleadings and what they contain. So the first one is the section 16 application. Like I've said previously, 16 applications are taken out to raise jurisdictional objections, stating basically that the arbitral tribunal does not have jurisdiction over the dispute. This could arise in various cases, such as maintainability issues where arbitral disputes are not capable of being arbitrated. Like Pratik had said, there are certain cases like tenancy, like matrimonial disputes, serious fraud, certain disputes relating to insolvency, etc., which cannot be arbitrated. So a party may then take out an application under 16 to say that there is a maintainability issue, the dispute currently is plagued by XYZ, and therefore it's not capable of arbitration. That could be one of the issues that is raised in a 16. Another issue that is often raised in a section 16 application is when the parties are non-signatories to the arbitration agreement. So you will find often that there are agreements where two parties have entered into an agreement, but there is a performance that is being made by a third party which is not related to the arbitration agreement. And in that sense, the claimant would have raised claims against the party which is a non-signatory. In such a case, what happens is either there is a jurisdictional objection taken before the court itself in either a 11 or a 9, depending on what proceeding is filed, or there is a jurisdictional objection taken in the section 16 itself, saying that the arbitration is not capable of proceeding because the party, one of the parties to the dispute against whom claims are raised, is not a party to the arbitration agreement. A classic case on this is that of chlorocontrols. It is the case which is cited on the issue of non-signatories and the group companies doctrine. Now, under that was under part 2 of the Act. Under part 1, the ruling in Sukanya Holdings holds the fort. Now, after this, really speaking, there could be a situation where counterclaims are filed by the defense. A claimant may raise objections against those counterclaims as well in terms of maintainability. In our experience, we have ourselves filed section 16 applications against counterclaims that are filed by defendants, and these arise where the claim that the defendant is making is extraneous to the entire proceeding. So if you have certain agreements and the defense is raising claims which are clearly barred under those agreements or which could not have been raised under those agreements, then one can obviously take out a section 16 saying that these claims are clearly barred and they have no bearing on this case and they cannot be raised before this tribunal. So therefore, there are various stages at which or various points at which a section 16 application may be taken out by either party. Now, section 16 applications, while drafting them, one must remember that the purpose is to raise issues of maintainability of the arbitration proceedings or maintainability of a certain aspect of the arbitration proceedings. So it is not required that a party gets into very heavy details on the factual elements of the dispute. The focus will be on the law and why exactly the arbitration proceedings or that aspect of the arbitration proceedings is not maintainable. These hearings typically take place in a day or 2 days, where each party is given a chance to make their submissions. And more often than not, section 16 applications are very heavily focused on what the prevalent law is. So section 16 applications are maintainability based applications. They are an important tool for both the defense and the claimant. And it is an important stage which the arbitration is really determined as to whether it can proceed or not. Once a section 16 application is decided, then the parties are both well aware of whether the arbitration proceeding can actually go ahead or whether it is at a finality right at the preliminary stage. Having said that, like I've said before, there are certain cases where the merits are so intricately tied into the dispute, where even raising a jurisdictional objection without hearing the entire breadth of evidence and appreciating the entire factual points is not possible for the tribunal, and they will then rule on the section 16 right at the end with the final award. So that exactly is what a section 16 application is. Let's also briefly touch upon what a section 17 application is. A section 17 application is one that is filed for interim relief. It is nothing but a section 9 application that is filed before a court, but now instead of filing it before a court, it is filed before an arbitral tribunal. So essentially everything that we've spoken about in relation to a section 9 petition before a court, in terms of urgency, in terms of showing that there are financial issues with the counterparty, dissipating assets, all of these issues will also form the heart of your section 17 applications that are filed before the tribunal. Now, section 17 applications are typically heard, unlike section 16 applications, which can be wrapped up and taken on with the final hearing and passed at the later stages. A section 17 is typically heard right in the beginning, because the whole point is that it is for interim relief. If that interim relief is not granted at the beginning of the arbitration proceedings, then really speaking, there's no point in that section 17 application being pending. The whole focus really here is to seek an interim award from the tribunal pending the final adjudication of the dispute.